And welcome back. So let's continue our conversation with 5th District Judicial Court, right?
5th Judicial District,
It's
Department
a mouthful.
1.
Department 1
Nancy Lord.
candidate, Nancy Lord. So Nancy, you were telling me how important it is that a judge actually has some feeling. I mean, you have to know the law, obviously, and know what you're about, but to have some care. And
Right, it's kind of like being a doctor in a way. The day that somebody can just die on the operating table and you just say, well, it's just all in a day's work,
right,
is the day to get out of medicine. You know, you need to care. It makes your job a little harder, but you need to appreciate what your rulings are doing to people. There was a case involving Judge Lane several years ago, right about the time that CCSC was getting off the ground, and we just had a ton of people coming to meetings. Donna and I both got a call on a Sunday that we needed to get our people out because they were trying to ban horses from Calvada. It turned out one family had sued another because they didn't want to be around horses. And the family had gone to not an attorney but a paralegal. The paralegal had placed into evidence the various covenants, etc., of Calvada, of the old preferred properties. I believe some of these hadn't been properly filed. I've had cases where I've had them knocked out because they weren't filed with the recorder's office. They were simply filed at the Calvada real estate office. Well, something like that is not a valid covenant. But the paralegal had put them into evidence. I didn't get my people out. I said, I'm not going to ask 80 people to come out on their Sunday and give their Sunday up until I know what the case is about. And when we found out what it was about, we chose not to have all our people show up at Petrick Park because the people were really not getting very good representation.
wow.
So I spoke to this paralegal, and I told him about, the covenants and needing to be recorded, and even referred him to a case that this had come up in for me. That Judge Lane had been the judge on that one as well. So he files another brief and asks Judge Lane to take them out of evidence. He put them in.
Wow.
Judge Lane had no choice but to say, hey, sorry, you put them in yourself. I can't exclude them now. He'd open the door.
Right. I can't act like I never saw it.
Exactly. And so there was this rumor floating, and the poor family had to get rid of their horse. It was terrible.
Oh.
And he really felt bad about it, and it was floating around the town that they were going to somehow take our horses away. Judge Lane took his opinion and placed copies of it in all the attorneys' folders at the courthouse, and with a note that this is, and I think he said even in the opinion, that this was one case, and it would have no precedential value for anybody else. It was simply the way the case was mishandled. It never got legs. Nobody else got sued. Nobody else had to give up their horse.
No precedent was set, and became
right,
a burden
right.
for everyone to live under.
Right.
That's nice.
It was just a lesson that people really, it's unfortunate when when somebody decides to sue somebody, if they can't afford a lawyer, they should just not do it. But when you get sued, that's a difficult position to be in because some people just don't have the money for an attorney.
Hmm.
And I don't know what we can do about that. Maybe people need to take more defense cases on contingency.
In every trial, would you say it's true that a judge has to look at precedent, has to look at the facts of the case in front of him, and has to think of the future of, am I going to set a precedent? Do you have to take all that in, or do you just look at what's going on right now, and that's weighted way more than what goes before and what might come after?
I think, not at the district court, I think it would be very rare that you'd have to worry about precedent.
Okay.
And even at the appellate level, the judge just looks at that case.
Okay.
And clearly if you make a ruling under one fact pattern, it will be expanded. They say hard cases make bad law. One example is the Raich case involving medical marijuana. There was a very positive trend at the Supreme Court dating back to, I believe, when I was in law school in the 80s, beginning with the Lopez case, which was a case involving, South Carolina case involving some beachfront property, where they finally started honing the government in on the expansion of the Interstate Commerce Clause. Lopez involved the guns within a school zone. That was overturned. At the time, there were no findings of Congress as to why it affected commerce. That was later inserted and it was reenacted. But there were several other cases along the line, and we had a nice trend of, maybe there'll be some limits on this. Maybe the Constitution will finally be upheld. And then medical marijuana in Los Angeles came along. And rather than wait until the right fact pattern presented itself, some lawyer charged in with Angel Raich, and there were problems with the case, and it lost. Under the old Wickard v. Filburn doctrine of a farmer growing wheat to feed his own cattle is affecting commerce, because if enough farmers do that, it's going to reduce the price of wheat. So the government implicitly admitted they were supporting the price of marijuana because they didn't want people growing it in their own homes for their own medical use. And that you couldn't just cut out the one area where it was not illegal when you have a broad statute that encompasses what's illegal in all 50 other states. Now that we have, 14 or 15 states that have legal med pot, it would be a much stronger case to be brought now than to have been brought when the Angel Raich case was brought and it was only California. And with the gun people, they were very careful. Nobody really wanted to go to the Supreme Court as to whether the Second Amendment applied to an individual or to a militia. And they waited. And when the Keller case came along, this was a policeman, a policeman who wanted his CCW and couldn't get it in the District of Columbia, and got a very fair decision that they can make reasonable restrictions, but they cannot absolutely bar an individual from owning a gun.
So this
carrying a gun.
This was done at the judicial level of not something real high up. It was done more at a local level?
No, it was the Supreme Court.
Oh, the Supreme Court,
It went to the Supreme Court, but both sides had been afraid of losing for like 40 years. The original case that went up that upheld one of the state restrictions, it happened because nobody defended it. And so it was thought out. The people on the side of firearms of the Second Amendment waited for the right pattern.
Interesting.
And you stop. So that's when precedent comes up, and it's really more, as I mentioned with Raich, something that the lawyers should be thinking about, not the judges on the court. The judges just have to rule on that case.
Okay. Well, you know what? We're going to take another break, and when we come back, I would like to talk about activism, judicial activism.
Okay. Yes, let's do that.
A favorite subject of yours, but not a favorite practice.
Yes.
Okay. Folks, we will be right back after these few words, so don't go anywhere.